Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about whether or not you need a will if you have a trust. Before I get to that though, I want to remind you, if you have questions about this or anything else related to estate planning or probate, you can talk to us over the phone for free by going to estatemeeting.com. Okay. This was a question that I had a potential client ask me today, and it's a good question. It's a question that kind of makes sense when you think about it, and I have an answer. So, to sort of go high level first, the purpose of a revocable living trust is really to create a place where you can sort of put all of your assets that will avoid probate and that will allow for the distribution of those assets according to your terms when you are no longer on this earth. And it also, if you think about what a will does, a will kind of does the same thing, except if you have a will, you have to go through probate to distribute those assets. So it kind of begs the question, if you have a trust, do you then even need a will? Like, why make a will if you have a trust, since the trust sort of does everything that the will does, except does it better? Okay, what's up, Andrew? But the fact is, a will is still very helpful, particularly in a couple of scenarios. Scenario number one: if you have children, a will is still important. Children under 18, a will is still important because the will is going to be the place where you name your long-term guardians. So, if something happens to you and your spouse, or you and the other parent, if you both are gone, then the guardian needs to be named in the will, or a court is going to make the determination about guardianship on its own. And we never want that to happen, right? I always think about that crazy family member that you have that looks really good on paper, but that you would never want to raise your kids. If you think you're that family member of mine, you probably are, okay? I'm just kidding. I love you all. But the will does an important thing. If you have children under 18, names long-term guardian. If you do not have any children, or if you have children that are over the age of 18 and you don't have to worry about guardianship, then the will can seem sort of duplicitous, sort of extra, but the will performs an important function that you never know when it's going to be needed. That important function is, it is a sort of a fallback in case you forget to put any assets into your trust. The will makes sure that those assets get into your trust. Let's say, for example, that this I guess potentially could happen. It's never happened to me. But let's say you come in to sign all of your documents. You sign your trust, you sign your will, you sign your power of attorney, medical power of attorney. You do all the things, and you walk out of the office ready to go and fund your trust, ready to point all of your accounts at your trust, ready to do all the things that need to be done. And on the way out of the office, a freak accident happens and you are struck by lightning and you're killed. So in that instance, you didn't have a chance to fund your trust. You didn't have a chance to point anything at the trust. In that scenario, all of your assets are going to technically pass under your will. The only assets that work under the trust are assets that are actually in the trust. But in this scenario, your will would capture all those assets, and then the will would direct that all of those assets be distributed into the trust, thus continuing to make your trust work, continuing to make your assets available in exactly the way that you want, and continuing to sort of like put all of the things together. So the trust is, or the will is sort of a catch-all, a fallback, just in case something crazy happens, just in case you forget to put an asset into your trust. Let's say, for example, that a relative dies and leaves you a large sum of money, and you die before their probate is done. In that instance, those assets from that deceased relative would technically go into your estate, and then would be able to pour over into your trust, and again, be distributed in the way that you want. Okay? So, although a will may seem duplicitous or duplicitous, I guess depending on how you say that C in there in the middle, it is a necessary part of your trust estate plan. It does perform a necessary service, an important service, and I would encourage all of you, if you do have a revocable living trust, to have a will, a pour over will that goes with that. And we sort of help our clients do that too. Okay, that is it though. Hopefully this made sense. Hopefully it was a helpful answer to this question. If you were thinking about or wondering about why that is, hopefully you are satisfied. If you are, hit the like button. If you know someone that needs to hear this, please share it with them. If you have a question or comment, please leave it. I will answer it. And if you want to talk some estate planning, if you need some help, if you have more questions, go to estatemeeting.com. You can talk with us over the phone for free, estatemeeting.com. Okay, as always, I am Christopher Small. I am the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again soon. See ya.